today's webinar. I want to welcome you all to this United Policyholders Roadmap to Recovery webinar. This evening, we will be discussing strategies for settling, answering the questions that came in advance, and then the questions that come in through the Q&A this evening. My name is Amy Bach, and I want to welcome you. And we look forward to discussing the pressing issues that may be keeping you from moving forward, or questions that you have that have not yet been answered. Just a little bit about United Policyholders. We are a 501c3, or not-for-profit charitable organization. We're reputable and established. We have been a trusted information resource and a respected voice for insurance consumers and disaster survivors in all 50 states for 30 years. We have a lot of expertise with regard to insurance, but also the full spectrum of challenges that wildfire impacted households have to navigate on their road to recovery. We're not for profit, not for sale, meaning we are not a front for anybody, any commercial outfit. We are a traditional consumer group. So we don't take money from insurance companies. We know a lot about insurance, but we're not here to sell you anything. We're here to give you information that's in your best interest and help you get the full value of the insurance that you invested in, and also make good decisions as you navigate replacing your destroyed or damaged possessions and dwelling. Our team, we call Team Up, consists of a professional staff. Tonight we have with us some of them, and I'll introduce you to them in a minute. Government and nonprofit partners, we have those with us as well, and volunteers, which include people who have expertise in some aspect of disaster recovery or insurance, and have an orientation to helping consumers. So we run 3 programs, and tonight's webinar is brought to you through our Roadmap to Recovery program, through which we have been guiding disaster impacted communities and individuals since 1991. We also do a lot of preparedness work, helping people take the lessons that people have learned the hard way when they've been impacted by a disaster, as far as not having enough insurance or not having good records, and then pay those forward to help people be better prepared for the future. And then we do advocacy work in legislatures or in the courts to try to fix problems that you may be encountering, and to make the insurance and recovery system work even better. We are the publishers of this book, the Little Yellow Disaster Recovery Handbook. I'm one of the authors. If you would like a copy, we have free copies available, and there's some really good home inventory help in that book. A little bit of fine print. We are giving you general guidance and information, not legal advice. If you have a specific legal question, we recommend you consult an experienced attorney. We have a Find Help Professional directory on our website, where you will find professionals that are consumer oriented and support our nonprofit. We're not here to endorse or warrant any of our speakers or create a professional relationship. We're here to give you information. So tonight's panel is pretty special. I'm very grateful and proud to have assembled representatives from 3 different state insurance oversight agencies, as well as bring you some of my superstars on our team. So I'm Amy Bach. We also have with us Val Brown, Carrie Waite, and Elise Hicks. And then our special guests, we have from the Colorado Insurance Division. That's the agency in Colorado that oversees insurance companies. We've got Tracey Garceau. With the Oregon Insurance Division, we have Nancy Yule. From the Washington Insurance Division, we have Josh Cully and Joshua Martinson. And then we have California Insurance Attorney Ben Souter with Kiesel, Young, and Logan. That's me, longtime insurance consumer advocate. Tracey is the lead insurance analyst with her state's Division of Insurance. Tracey, did you want to say a few words?
I just want to say thank you, Amy, and United Policyholders for asking me again. I've enjoyed this. It's really valuable to our Colorado consumers and to Colorado consumers and all state consumers. I feel for your loss, and we're ready to help where we can.
Thank you. And for each of the agencies that's here, we have, of course, the basic information of how to reach them. They all have toll-free numbers. They all give you information on their websites. I know that the Washington division actually has a chat feature where you can chat. I don't know, Tracey, if you guys have that, or pretty fancy. Okay, so next, Nancy Ewell with the Oregon, the Division of Financial Regulation and Consumer and Business Services, lots of syllables there. Nancy, thank you for being with us. Would you like to say a few
Amy?
words?
Sure, thanks for having me. I really appreciate being part of this really important discussion. So we are the Oregon Office of Insurance Commissioner. And so we regulate the insurance industry, the producers, the agents, and of course, the adjusters. So, we really encourage folks in Oregon to reach out to us, particularly if they're having challenges. Our advocates are there for them. These are insurance experts who, for free of charge, can make sure that the insurance company is following the Oregon laws. So we'll keep sharing this contact information throughout the evening, and do please make note of it if you're in Oregon and part of this, listening to this webinar. Please reach out to us. We're here for you. And I look forward to the conversation tonight. I hope we can answer lots of questions for you.
Great. Okay, and here is the toll-free number for Nancy's agency. We're going to repeat it later on as well. And copies of the PowerPoint can be available to you. Just have to email info@uphelp.org and we will shoot it to you. But this is from the Oregon Department, and Nancy will explain later about the rebuild agreement there as we answer questions. From the Washington Office of the Insurance Commissioner, we have Josh Cully and Joshua Martinson. Josh and Josh, hi.
Hi, thanks for the introduction. I'm excited to be a part of this as well. I'm Josh Cully, and I'm a little newer on the regulatory side, but I've been in the insurance world for the past 17 years on the sales side, the marketing side, the underwriting side. And so you might, say that I've got some insider information on what the companies are doing, and we'd be happy to field any kind of questions along those lines. And I have with me Josh Martinson.
Great. Yeah, I think I think a lot of folks that work at state insurance regulation offices came from working for insurance companies and have a lot of pragmatic experience. Tracey brings that, and Josh, you as well. Nancy, I don't know, did you work at an insurance company before you joined the department?
No, I didn't actually. My background is consumer finance.
Ah, okay. All right. All right. Well, all super, super helpful. And then this is the Washington State office. Again, all three of these agencies, and so does the California Department, have toll-free numbers, and it's free to use their services. That is part of what they're there for. They're there. All those agencies are there to make sure that insurance companies have enough money to pay your claims, but they're also there to make sure that insurers are delivering on the promises that they make to you and abiding by the laws in the state. And when that doesn't happen, they want to hear from you. And we certainly, as a consumer advocacy group, encourage you to take advantage of them as a resource. This is a document from the Washington Insurance Commissioner's Office that is helpful in understanding the different kinds of adjusters. And there's all kinds of information on all three of these agencies' websites, as well as the California Department of Insurance. And they are frequently with us on our workshops, just not tonight, but very often there will be somebody from the California Department with us. But we have another special guest that rounds out the expertise. Ben Souter is an attorney in private practice in the Bay Area of California. And we invited him because he has fairly recent, very relevant experience in assisting his clients in reaching settlements with their insurers, and particularly clients who have been underinsured and needed a professional to help them negotiate behind the scenes. And on the topic of underinsurance, which is probably one of the biggest challenges that wildfire impacted households have to overcome, it's a tough one because the law is not as helpful as we'd like it to be in terms of whose responsibility it is to set limits adequately at the point of sale. So there are a lot of arguments that can be made that the insurance company had the responsibility or undertook the responsibility and should make right on the fact that they didn't put enough coverage on your dwelling. But it is something that often does require a lawyer and often happens behind closed doors in a confidential setting, because insurance companies will tell you, well, we don't want to set a precedent, and we don't do that. So Ben, if you wanted to say a few words, welcome.
Thank you very much, Amy. Thank you for inviting me to join this terrific group that we have here. And thanks to the folks that are listening in for your interest here. We are here to help. We are here to educate. And we know that you wouldn't be on these sorts of seminars if you hadn't already suffered disastrous losses. The problem many of you are encountering is facing a second disaster, and that's having to deal with your insurance company that's being less than cooperative or less than forthcoming with either information or money. So we look forward to answering your questions, and my thanks go out to Amy as well for the great work she's done for 30 years and this wonderful organization that helps folks that truly need the help. So look forward to
well, thank you, Ben, and all of you. Just a couple more information shares. For those of you who, if this is your first time coming on to one of our workshops or webinars, we have set up libraries for all 4 states that were impacted by wildfires last fall. So we have a California library, we have a Colorado library, Oregon, and Washington, and you will find locally relevant information in those libraries 24/7. Just a few more reminders before we get into your questions. Knowing your rights is, of course, very helpful to getting a fair settlement with your insurance company. And a few realities that I'm sure all of you know already. You don't need me to tell you, but it's very common that you will have a succession of adjusters, that you will get 1, 2, sometimes as many as 10. We've heard as many as 12. Rotating through your claim during the time it takes to get it resolved. And sometimes that can be very frustrating, and it can cause delays. And so that's one of the reasons why we really encourage you to keep a journal all the way through. And just a reminder, there are 3 primary sources that dictate how your insurance company has to behave related to your claim. The laws in your state, and laws can be on the books in a statute, or they can be from cases that judges have handed down. They can be in regulations, bulletins, and notices that the agencies that we've got with us tonight put out, or that regulations that are actually in the state's law books. It also, your rights come in, are written out in your specific policy, including all the pieces of it, which in insurance lingo are endorsements, exclusions, declarations, riders. And then the 4th place that you get rights to be treated fairly is something called the Covenant of Good Faith and Fair Dealing. And it's really just a very common sense notion that courts have been upholding for many, many years, that it's sort of like invisible wording that's read into your policy. Now we have it in California very clearly. In other states, it's really more of an often a matter of common sense to say that your insurance company has made promises to you to be there for you, and they make those promises in their ads. They make those promises when they sell you a policy, that they will treat you fairly, and that they will act in good faith, that they will be reasonable. And so that sort of invisible language gets read into your policy, and requires the insurer to behave reasonably. And when they don't, they are subject to being sued or being fined, or being penalized. So you have a lot of rights. It's just often a matter of figuring out how to assert your rights in a way that is practical for you. Journaling and keeping a good paper trail is one of the most important things. And your communications should confirm you're cooperating with your insurer's investigation. Tell them what you need or want and why. Ask them what they need from you to resolve your claim. Point out specific things they have or haven't done that are holding up your settlement. Politely remind them about your challenging situation. Give them a specific time frame, and then be a real pest, but a polite pest. Follow up again. And then just a few more points about best practices for negotiating with an insurance company. Yeah, you may be having rotating adjusters. Some of the adjusters may be very green, they may be very young, some of them may be more experienced, some of them may have a chip on their shoulder. But for you, our advice, having worked with so many people in this challenging situation over the years, is to look at your claim as a business negotiation, and as emotional as you feel. And that's, of course, completely normal and legit. It is really, we want to help you get out of this as painlessly as you can, as far as the insurance claim goes. And so we just really recommend doing your best to keep it's business. Even though the ads that you see on TV make it seem like there's sort of more like of a caring aspect to it, it's business, right? You want a certain amount of money out of the insurance company, you want it, and you want it timely. Keeping your goals in mind, these are our suggestions for being an effective negotiator. And of course, key to that is your leverage. Where do you get leverage to get an insurance adjuster to do what they may be hesitating to do? You have personal leverage, right? There's an empathy factor, but then insurers have made concessions to other people, and it's okay to ask that they make those concessions for you, such as lightening the load of your itemization of your inventory. Going up the chain, this is just basic of dealing with a large corporation. But we have brought these folks with us tonight because they're part of what gives you leverage, right? Vague threats to sue are rarely effective, but filing a complaint with the state agency in your state that oversees insurance companies should be a no-brainer for you, because it's free leverage, right? Because the insurance companies, these folks are not exactly their bosses, but they have power over the insurers because they license the insurers to do business. They can issue fines, they can issue penalties, but they can't be a free lawyer. So we always recommend that you make yourself heard, use their resources, open a request for assistance or a complaint, but keep your expectations reasonable. They cannot be your private lawyer. And that's one of the reasons we have been here, because there are many situations where a state insurance department can say, we see your problem, but there's a fact dispute and we're not at court. So, that's sort of, there are limits to their ability to help you. But they give you leverage. absolutely gives you leverage, right? A lot of people tell us, well, I'm afraid to file a complaint because I don't want to get my insurance company mad, then they're going to treat me worse. But it has been our experience that filing or that engaging with your state insurance department will actually help solve a problem. And it is illegal for the insurer to do anything in retribution against you for filing a complaint, exercising your right as a consumer. Okay, so we're going to jump right into our questions finally. And we're going to start with a question from Astrid out of California, asking that we clarify the difference between replacement cost and actual cash value. I think this is meant to say, regarding a dwelling and how insurance companies arrive at the figures. So I want to start, maybe Josh, if you want to, since you shared that you have a bit of experience in on the insurance company side, can you just sort of clarify an answer to this question?
Yeah, absolutely. So they're very, it is important to know the difference because the payout is very different between the two. Replacement cost is what it costs just to get another one of those things that was lost. So if, for example, if you had a TV that was 7 or 8 years old and it was lost in a fire, you don't want to get paid enough to buy another 7 or 8 year old TV because that value is just about nothing. With the cost of technology and all that, and so you're going to want a new TV, and so replacement cost is designed to basically replace what you lost in a new environment. Actual cash value takes into account depreciation, and so in the case of a computer from 1982, for example, there's not a lot of actual cash value wrapped up in that. And so you wouldn't expect to get much from that. To the question of how insurance companies arrive at the figures, there are depreciation charts that are used. Everything kind of has its own classification: furniture, clothing, computers, different technologies. And so there's a chart that's used to determine that. Some of that can be disputed if it seems like it's being unfairly depreciated, but you might have to get an independent evaluation on that. But again, the replacement cost is what it takes to get another one today. That's basically a functional replacement in new condition for you.
Okay. And of course, this is one of those kind of rude surprises that a lot of people encounter after they have a loss, that there is such a thing as depreciation that will be applied, and that the insurer very often is going to hold back a sum of money until you replace. But that is the way that insurers have been doing it for a long time. Now, there are situations where an insurer will not hold back, where they will, and particularly when people are underinsured, we have seen insurers cash people out for sure, and not even bother with depreciation because the person is so underinsured. But again, that would be one of those situations where there's a negotiation, right? And we're here to tell you that it's not like there are no rules. Of course, there are a lot of rules here. But insurers make business decisions. So, giving them good reasons to make a good business decision is kind of our theme tonight. Tracey, anything you want to add on this point?
One of the things we've seen in Colorado, excuse me, that's squeaky toy.
Fine.
Adjusters that are just using a standard deduction across a depreciation amount across the board. So don't let them do that, right? It's not just the age of the item that should impact the depreciation, it's the condition. So if you have a room where it's a guest room and it's hardly ever used, and you may have bought that furniture at the same time you bought your living room furniture, but they're definitely in different conditions. So I would just, I know it's tedious and it takes a lot of work. It's painful, but really look at what they're doing and call them out when they're incorrect.
Yeah, absolutely. Condition matters. And also depreciation is subjective. Just, as Josh said, there are charts, but different insurance companies use different charts. And lots of information on this topic on our website. So underinsurance, very common challenge, as I mentioned earlier. Paul from Colorado shares my rebuilding estimates 120,000 over my policy limit. A great deal of the gap is due to increased material costs. Will insurance companies cover these costs? That's the very hot topic. The cost of lumber has gone crazy, labor so high. Nancy, do you want to, I'm sorry, Colorado, that's Colorado. We're going to throw that to you again, Tracy.
Unfortunately, we've heard this from so many consumers, and a claim is often a snapshot in time, right? So they're going to look at the prices the day that the loss occurred. In Colorado, the material costs are going up for wood. I also heard from a consumer the other day about concrete is also backed up as well. The policy is the policy. The limits are the limits. I mean, you can always check back and make sure that your application was processed factually and that the limits were what you thought they were. But the ultimate is what's in the policy. I should say in Colorado, the commissioner is well aware of this situation. He's well aware of it and he's very empathetic. So if there is anything the division can do, we certainly will. But and that may include getting companies to release coverage dollars that may have been held until incurred. So sometimes the excess building costs are usually held until the home is rebuilt. We're getting those released earlier, asking companies to do that on a signed contract. But the companies they won't be paying anything extra contractual voluntarily.
And by that, she means above what technically they owe after you have considered all the endorsements that are part of the policy. So if you have extended replacement costs, I'm guessing that's not going to help you here either, this Paul, that the limit that you put at 120,000 includes any extensions you might have. But of course, that's always should be part of the equation, is make sure that you that you're finding all the dollars that are available in that policy before you figure out exactly how much is available to you. And again, on our website, we have a whole section about what do you do when you're underinsured. And in this question speaks to, it says a great deal of the gap. And of course, you know, extended replacement cost endorsements that are pretty common these days, 25%, 50% that increases your coverage A, those are supposed to account that the justification for those is to deal with post-loss, what's called demand surge or increases in material costs due to more people needing services. But obviously it doesn't always do that. So Ben, I know you're not a Colorado lawyer, and we did do, for those of you who are on tonight and maybe you don't know this, we actually have a whole recorded workshop that we did with a Colorado lawyer on this topic. Colorado law is just as challenging as California. So Ben, as far as the shortfall partly having to do with increased material costs, obviously that's not the only reason. What have you been counseling people, or what do you feel like is the best guidance you can give people at this point about whether or not they should pursue a remedy in the situation?
Sure. My starting point is always, was the property underinsured? And if so, why? The general rule is, as you pointed out, Amy, that the courts tend to think that consumers pick the amount of insurance. Well, as a practical matter, that's not the case. The insurance companies' computers pick the amount. The agents themselves determine what to pass on to the client. And most clients, in fact, none of the clients that I've had any decision-making with respect to the amount of the insurance that they obtain. So the starting point for me is, what is the reason for there being underinsurance, and were there misrepresentations or promises that were made? And if so, or were there mistakes made, the wrong square footage or something like that? Those things, to the extent that there's a viable underinsurance claim, it's my position that any increased costs for lumber or for delays, those are on the insurance company's nickel, for the following reason. Had they done their job properly, the house wouldn't have been underinsured, and the extended dwelling replacement costs factors would have come in to account for demand surge and those sorts of things. Now, obviously, every instance where a client feels that they're underinsured, there may be good reasons why. Maybe the insured wanted to lower the amount to save some money on premium, but that's generally not the case. So I would say if it's an underinsurance situation, don't necessarily conclude that the snapshot on the day of the fire and the attributed cost as of that day is the only amount that you can recover, because sometimes it takes years and years for the problems to get sorted out with the underinsurance. And if the price of lumber triples, as it has in the last year, and the cause of the delay in coming to the reformed policy is because of what the insurance company has done, my view is that it's their problem and it should be part of an overall settlement.
Yeah, and I'm with you there. I just, at United Policyholders, we try to give people very pragmatic information, not raise your hopes unreasonably or discourage you. We want to kind of try to give you what we have distilled as the strongest guidance that we have harvested from all of the experience, and that not just our team, but all the fire survivors that we've worked with over the years of experience. We've known many people who have been able to negotiate an above limit settlement, but as I said, it's almost always behind closed doors, and it's always where there are strong facts as to the homeowner reasonably relied on the agent and insurer to have gotten put that dwelling limit right. So like Ben mentioned, that situation of, well, if you call your insurer and said, listen, can you bring the premium down a little bit? That's usually not going to help an underinsurance claim, right? That's going to hurt. And we don't recommend that you throw good money after bad or good time after bad, trying to get a remedy from your insurer if the facts are not going to help you. But if you have good facts, if you have any kind of paper trail whatsoever about communications with the agent and or insurer where you said, I really want to make sure I've got enough insurance, and they wrote back or emailed or sent you something saying we have adjusted your limits or you're fine, that can be, if you have any kind of proof like that, that can make a huge difference in your ability to either negotiate an above limit settlement. And there have been a number of lawsuits that have been filed on behalf of large groups of underinsured people, and many of them have settled, but again, confidentially. So this is a sort of challenging, but not impossible situation to fix. Code upgrades. This is an interesting one, and Josh and Nancy, if you guys have any thoughts on this from the Pacific Northwest, I want to hear them. Should code upgrades be included in the replacement cost value? Nationwide is denying inclusion until the cost is incurred. We intend to repurchase, not rebuild. Now, this may be unfair to ask for the Oregon and Washington people, because you don't have the law we have in California, which says that the insurer has to pay the exact same amount toward the purchase that they would have had to pay if the person rebuilt. So is there any law in your states whatsoever on the consumer's right to collect their code upgrade coverage if they haven't incurred it?
So I'll go ahead, Amy. So in Oregon, we don't have that on the books to allow that to happen. So if someone's taking their settlement figure for repurchase, they're just going to get their full coverage as laid out there in their policy. So they would not get the code upgrade. Okay.
Josh, same thing in Washington, correct?
Correct.
Okay. All right. So in California, and Ben, I don't know how, if you want to speak to this or if you just want to have me speak to it, your call.
I'm happy to address it from a practical point of view.
Go for it.
Whenever we've resolved these matters, and again, these are all solid underinsurance claims. Not every case is going to be like that. We've always gotten thrown in the full amount of code upgrade after the Reformation.
So we have and see, this is the, you know, if every lawyer were as good as you, Ben, it would be a different situation. On the other hand, you're living proof that it can be done. Okay, so you can negotiate to collect your full policy limits, even if you haven't incurred the code upgrade costs in California, because the legislature enacted a law that that says that you can. So we have that, Jane, in California. But nationwide, and a couple of other insurers seem to be digging their heels in, and there is a lawsuit pending about it. And we have brought this to the attention of the California Department of Insurance. The California law is very clear now that if you replace your destroyed home by buying, you do not need to incur code upgrades to collect the amount of benefits you had for code upgrades, as long as you can establish that had you rebuilt the home as it in the original location up to current codes, you would have been required to make upgrades, and you would have had to make those upgrades, and therefore you get your code upgrade coverage toward the purchase of the replacement home. And that just brings back to that you have to reach an agreement with the insurance company before you figure out how much money you have available to buy a replacement home. You need to reach an agreement with the insurance company as to how much it would theoretically cost to rebuild that home at the original location in compliance with building codes. And very often the insurer will require you to prove the code upgrades. And to do that, you often will want, and you need to have a construction professional give you a breakout of the code upgrades in that hypothetical project. And again, we have materials at our website that will help with that. Another ACV question from Jane. In California, ACV, once the values have been agreed upon, is it possible to negotiate a higher ACV by offering to not go the replacement route? We're leaning toward using the 1.5 million to replace our home, but if you'd be willing to split the difference between our ACV, we'd save you the other half of that difference, go the ACV route. So I guess this is an interesting, I'm going to throw this first to you, Tracey. This is an interesting one. It kind of speaks to, you know, the kind of give and take in a negotiation. Does this make sense to you?
Yeah. So again, there's no statute, so you go to policy, and policy really doesn't talk about that to that granular detail. I think reading this, I hate to see anyone leave any money on the table. I really don't. So I don't know the reasoning behind this question, why you would be willing to negotiate, maybe just to end the claim, right? And that's a valid decision to make. I have found though that although some companies are agreeing to something like this, they're cashing out on ALE, their alternative living expenses, and other portions of the policy. I haven't seen it done on all cases. So there is a big difference when there's no statute and policies differ, or there's ambiguity. It really comes down to a business decision for the company. And I would say try it, right? I mean, make the case for it. Again, I just don't like to see people leaving money on the table. You pay premium for that. But if it suits your circumstances, then yeah, I would say try your negotiation skills.
Ben, anything to add from the California perspective?
You know, my view is consistent with Tracey's, I guess, that, you know, you shouldn't leave money on the table. I'm not sure that I'm fully understanding the question, because usually there's the replacement cost value, and then the insurance company or some third-party outfit will, give the actual cash values, and they'll say, this is what you're entitled to, the actual cash value, as opposed to the RCV. So I guess that's the splitting the difference. But to me, I've seen a lot of ACVs that just are, randomly picked out of the sky, as far as I can tell. They have different percentages and different computer programs, and sometimes a refrigerator will be valued at 90%, and the stove bought at the same time will be at 40%. So it's just, I would attack the ACV as not being, justifiable, rather than just accept that and then split the difference.
Yeah, reading between the lines here, I think this person would like to not have to spend the money on the replacement home
Yeah.
and would like to just do a cash out, is what I think I'm reading. But Tracey, would you?
Just based on my experience, I think if you do ever come to some kind of negotiated settlement like that, they're going to want a release of some kind, saying that you're going to take this and you're going to walk away and you're not going to come back for any more. So I think this is a really serious question to consider all of the consequences of it as well, because there may be other things that you might be entitled to that you don't know of right now. Or I just feel concerned when you're giving up your first party contractual rights for a negotiated settlement, especially when it's not limits.
Yep. Okay, I see the questions are building up there in the Q&A, so I'm going to try to move a little faster here. All right, ALE, which also often gets referred to as loss of use or temporary living expense. So this person is asking their insurance company to give them a detailed breakdown of the ALE payments to date, but they're not giving that to them. Now, California does have a law that says that the insurer is supposed to tell you what common items are that you can claim for your temporary living expense. But asking an insurer to give you a breakdown of what they have already paid you, this seems like sort of a generic question that any of you could speak to. So Josh, is that something that you would feel comfortable asking an insurer to do, is to, give this person a breakdown of everything you've paid so far on the claim?
Yeah, this is one of those reasonable questions that an insured can ask, and at least in Washington State, and I'm sure this is everywhere, the insurance company has to respond. A request being ignored, once you're beyond the 10 working days, at least in Washington, is a violation. And that's something that we would take into consideration as well if we ever took any kind of action against them. But if pretty much anything you ask your insurer, if you've got questions about either what's going on with your policy, what's going on with your claim, what have they paid so far, that seems like perfectly reasonable things to ask, and it will allow you to be able to figure out, well, how much do you have left, because if your policy has a limit on that kind of thing. So next move might be to check with your local insurance commissioner to see what the insurance company is required to do as far as timeliness, and perhaps go that route, go through the regulatory route.
Yep. Nancy, same.
That's exactly what this is. A classic case of give a consumer advocate a call. Just having that advocate inquire with the company about it suddenly can release the information, right? So this is a classic example of where you'd want to use your insurance commissioner's office to protect your rights to get that information.
Yep, absolutely. Public adjusters. Okay. We received an inaccurate exactimate estimate, exactimate being the computer program that a lot of insurers are using today to come up with a number on what it should cost to put your house back. Then this person got a new adjuster. It sounds like update. Okay, so this person is having problems with their adjuster. Aren't we entitled to an estimate? I'll tell you what I'm going to do for Rena. This is a good question for the California department. And you certainly are entitled to an estimate. You certainly are entitled to ask for a replacement adjuster if your adjuster is not being cooperative. So given that we don't have a California person on from the department, but we certainly have Ben, And we have other agency folks here. Do you get questions from Tracey and Josh and Nancy? Is if a consumer calls your agency and says, my adjuster's being a jerk, I want a new one. Is that something you can help with? And do you get those kind of questions? Nancy, to start with you.
Sure. We couldn't directly help with that, but we would say, yes, that's a valid request to make. What concerns me here is that the relationship is damaged. He's by their account, he's behaving like a big bully. And so it's not going to bode well for the rebuild process, right? This is the beginning of a relationship that needs to be very professional and very respectful. So I think they're well within their rights to go to the supervisor, go to the insurance company and say, we'd like you to assign someone that we know we can be really productive with, that we can cooperate with, that we can get a good result from. So start with the company, and if the company's not responsive, then turn to the advocates in the commissioner's office and say the company hasn't responded to my request. I think that's well within their rights to do that. It's so important to have a professional relationship with these folks. This is going to be a long haul. It's not easy in the best of times.
Yep.
And if they haven't even started, hammering those nails yet, it's only going to get worse if they don't have the right person working with them.
Absolutely. Josh or Tracey, anything to add?
Yeah, it's probably important to note that while we can request it, this is one of those areas where we can't enforce it. There's nothing in statute that says that upon insured request we can demand that they swap out their adjuster. Although asking us, it does put some weight in the request, because that request is not just going to go directly to that adjuster that you've been working with. It's going to go to their supervisor and their supervisor and their compliance analyst. It kind of filters down that way.
Right.
And everyone along that communication path might just agree that this is not a good relationship. And that's probably a good way to get that communication across.
Yep. Ben, does this look to you like evidence of bad faith, or is this not rise to that level?
This is evidence of somebody being a jerk, I think, and first step to being bad faith.
Okay.
I agree that with Nancy, this ought to go to the supervisor level, and it should be politely documented. One of the things that I've seen problems with is when clients, before they have contacted us, have gotten into these back and forths with different adjusters, and the heat goes up and the language becomes looser, and it gets messy all around. I think two guiding principles in any dealings with the insurance company are the following. One is to be 100% honest and straightforward, and the other is to be professional and polite. You get way further in the process by proceeding in that manner. Banging your hand on the table and screaming bad faith gets you nowhere, and it sets up more of an adversarial relationship than otherwise exists. So I think politely requesting a change of personnel is 100% appropriate, and if that's not honored, then that gives you some indication of how tough it's going to be to have a good relationship with the insurance company. I'm sorry.
I would just say, I think you mentioned earlier about journaling. I think this is a case where we can emphasize the importance of emailing, right? So you have a conversation with anyone in the company, and then you memorialize that conversation, and you get commitments. So if they said 2 weeks, it would do. So you would write an email to the adjuster, based on our conversation today, I can expect an updated estimate on such a date. And if they don't reply no, then they're basically accepting that and saying yes. I think that is one way. And one thing about the emails I would say as well, keep the coverages separate. There's nothing worse than like a trail of emails and it's going all over the place. So just work on, if it's a dwelling issue, it's talking about—
Address one issue at a time.
Yeah, actually, because it's so difficult to break those out when you need to. And also now you're creating a paper trail in case you do need to escalate this civilly after the claim is over.
Yep.
Great.
All right. Let's see, another question, very similar to the one we had before about construction costs. And I think we answered this question that that technically, increased costs were supposed to be covered by extended replacement and or anticipated by the insurer. I mean, it's not like this is a new phenomenon that construction costs go up. But anyway, I think we've addressed this. It's going to be an argument, but the policy limits are what they are. Contents and inventory. Is there any strategy for getting the final 25% without doing the complete inventory? This is a California question. In California, also in Colorado, there is a law on the books, and there will be well, I don't think the Oregon, well, never mind that. There's a pending law in Oregon that may touch this, but usually when the insurer says, we're going to waive the itemization, we're not going to make you itemize, but we're not going to pay you your full limits. We will offer you 75%, or the Colorado law is 30%, which we certainly wouldn't encourage anyone to take 30. In California, there has been a history of insurers offering 75% of your contents with limits of benefits without requiring you to itemize, but they were doing that as sort of a PR strategy. But in all those situations, they always say, if you want more than what we're offering, you are going to have to itemize from $1, which really is it's a real problem, of course, because you're sort of, it puts you between a rock and a hard place. Is there any strategy for getting the final 25 without doing the complete inventory? Not that I know. So anybody else have anything on that?
I'll speak to that.
Oh,
All right, go ahead.
all right. I don't have a strategy, but I just have a perspective I just want people to think about in this. It's in that last 25% that the accuracy of the valuation comes out. So that's why it's there. Do you see what I mean? The settlement amount for personal possessions is a fixed amount, and it's when you inventory fully that you see whether or not you're reaching that full amount. So it is in that last 25% that the accuracy comes into play of what the full value is. And that's why they enforce that final 25%. So I don't have a strategy for getting it. I just think that's going to be those last dollars are going to be the hardest to negotiate without your detailed inventory. So I would say, rather than trying to put energy into negotiating that, try to put energy into doing a really detailed inventory.
Very good. Okay. Next.
Amy, I'm sorry. I was just
No,
gonna add on
we
to
can go
that,
back. We can go back. I'm just
very briefly,
looking at
in the underinsurance context, if there is a valid underinsurance case where upon reformation, there should be another 60% or 50% or whatever number is chosen. In some cases, it's been 200% in some of the situations I've been involved with. All of the other coverages play off of the coverage A.
Right.
And so if you're increasing your coverage A by 50%, you're going to increase your contents coverage proportionately. And if they're going to pay the 75%, don't give up on that until, again, in the under insurance context, until it's been resolved what the coverage A is going to be, because that correspondingly should increase everything else. And if they're willing to pay 75% and it's higher than what was originally the 100%, you can be better off that way.
That's helpful. I mean, you're entitled to 100% of your contents coverage, right? No matter what. The question is, it is very frustrating to have to go back after you've thought, okay, I didn't have to do that, and now I have to. The bottom line is that if you're willing to do the work, and United Policyholders offers resources to help you with your inventory. We have sample inventories, completed inventories with pricing and not pricing. We have an Excel spreadsheet. We've done a number of workshops to help you itemize your contents inventory if you want to get your 100%. Other than that, it's a negotiation. Okay, let's get to the next one. Replacing by buying. If I choose to buy elsewhere, can I hold on to that money? Who will regulate how I spent those funds? Okay, so Luke, we did a workshop a couple, like maybe a month or two ago, where we had somebody in California who lost his home in a fire in it was, I guess it was what was called the Butte Fire, Calaveras County. And he was insured with State Farm, and State Farm offered him a check for the amount of his coverage A, and he was underinsured. I don't know if he thought he was, but I think we all know now in hindsight that he was. And he said to the adjuster, well, can I just take this all and put it on black and go to Vegas and put it on black? That was his way of asking, are there strings attached? And the adjuster said, I would really recommend that you not do that. But we don't care what you do with the money, as long as you sign a release and you let us out and we're done. Now that's, kind of one kind of adjuster. Panelists, where will an adjuster typically want to make sure that you actually use your content, your coverage A settlement to replace your home? Is that obviously that's sort of the letter of the contract? Does that always happen? Josh, you want to start with that?
Well, I think most homeowners have a mortgage, and so they sort of have the first rights on large settlement checks. So there's a certain dollar threshold after which the insurance company has to list the mortgage company as a co-signer on that check. So that often gets in the way of being able to run to Vegas with that money. But for a person who has their house completely paid off, at least in Washington, I am not aware of any requirement that the money go towards rebuilding the house. I know that like for example, in the case of a partial loss, the insurance company, if you intend to continue to keep the house insured, might require an inspection to confirm that the work has been done, so that you don't try to claim on it again in the future. Leaky roof, for example, those kinds of things. But in a total loss, I don't think, apart from the mortgage company being an impediment there, I don't know that there's anything in Washington that precludes a person from taking that money and doing whatever it is they want with it. I mean, sell the dirt to the next developer and build your house elsewhere, I suppose.
Mm-hmm. Nancy or Tracy, anything to add?
No, I mean, that I was thinking the same thing about Josh is, who's the first lien holder on that, and just make sure they're whole. And then, check with your tax accountant to make sure that there's no tax issues associated with that.
Right.
Yeah, and I think most of the carriers in Colorado, they're releasing all of those withheld funds, like RCV, the replacement cost difference and so forth, until you give them a signed contract. I don't think they're going back to make sure that the closing went through. I think they're just accepting the signed contract and moving on. So.
Yeah. Ben, anything to add from California?
I really don't. I think it's been pretty well covered there.
Yeah, I concur. I mean, it really depends on the adjuster, but it is, as everybody has said, it's really important to clarify and make sure that there's no lien holders that you have to satisfy. So, okay, so the rest of the PowerPoint, we've gotten through the questions that came in before. We have quite a few questions in the Q&A. We're probably not going to be able to get to all of them, but we will do our best. The rest of this PowerPoint, which will be available on request, gives you the some of the laws in the various states, California and Colorado, on how your insurer is supposed to be handling your loss and what your rights are. We've got sections of the law in Colorado, sections of the law in also in Oregon and also in Washington. But I'm going to turn to my team and ask Carrie,
Yes, I'm
Hopefully
here.
you guys have grouped some of these. I think we have a lot.
Yes.
So yes,
We'll
ahead.
we'll
Let-
get going here.
let's
and-
start with if we have Washington questions, because I know our Washington folks have a limited time with us, and we're
Well, we don't necessarily have them
Okay.
all by state.
Okay.
So, but we do have several that are similar. So,
let's just, yeah, we don't have to, go ahead.
okay, so this is from SJ, and I have received my structure payout, but it's less than I think it should be. I had a licensed contractor create a detailed document of the cost of replacement and submitted that to my adjuster. What are my rights regarding this? In California, are they required to honor this?
Ben, you want to take a crack at that?
Sure. The insurance company has its own estimate of rebuild costs, and it then asks you for yours as well, the consumers as well, and it'll often side with its own and decide that the structured costs, whatever they are from the consumer's contractor, are too high or beyond the limits. That problem doesn't arise when the costs exceed the amount of the coverage A. But I think you just need to insist that you were given, for example, if you're given full coverage, regardless of the actual amount, if you have a legitimate basis for saying, I thought I had full coverage and this is what my contractor says it's going to take, you can and should insist upon that. The insurance company may say no, but if you exceed or agree to their number, then you've created a problem for yourself. So in my view, because so many of the homes in California, 2/3 are underinsured, you shouldn't just agree with the insurance company's bid, and you should insist if there's full replacement cost coverage, especially if there's extended cost involved, that it be covered. And they may, in many cases, they won't agree with you. In some cases, they may. I'll just give you a quick example. As a result of one of these United Policyholder seminars that I had a minor role with in the past, one of the insureds wrote a draft letter, asked me to look at it. I made a few corrections to it, and he politely asked that he get more than what the policy was worth so that it could in fact be enough to cover his contractor's bill. And the insurance company, on the basis of a single letter, agreed to increase his coverage A amount by 60%. He was delighted with that, and the problem got resolved. But initially they were resisting them. He told them, no, this is all we're going to give you. And he explained, and they did. So things can happen. It's on an individual basis, but don't give up.
Yep. Very important. Okay, Carrie,
Okay.
next.
So I'm gonna jump to DR because it's a similar line here. We received a low estimate from State Farm, so we countered with an estimate from our contractor. How long is it normal to wait time-wise for the insurance company to get back to us? We have had several questions along these lines that it's taking a very long time to hear back from the insurance company when they send a contractor estimate.
Okay, well, that's a good one for everyone, all the 3 states, because you all have time. Every state has all 4 states. Every state has rules, right? 40 days to pay or denying, or how many days to respond to a letter. So Josh, what do you guys do for Washington residents who are feeling frustrated with how long it's taking for the insurance company to get back to them on a communication or an estimate that they're waiting to hear? Is there a thumbs up or thumbs down?
Right. What we sometimes find, first that 10 business day in Washington state, that stands, then it needs to be a response. But what we sometimes find is going on in the background where maybe the insured doesn't realize this. is that there's a lot of back and forth going on between the insurer and the contractor. That some of those conversations are going back and forth. So when we, my team of analysts, when we reach out to the insurer, we ask for an adjuster synopsis so that we can confirm that at least some conversations have been going on. And it's sometimes the delay is really not on the insurer's part, but actually might be because of the contractor involved. It doesn't mean that the insurer doesn't respond to the complainant, of course. I mean, they still have to respond in some way. That 10 business day response time still stands. But again, some of the back and forth is the cause of some of that extended delay. And I think that's something to ask about as well.
Mm-hmm. Nancy, anything to add?
It's just similar in Oregon. If you filed a claim, then we have a time limit on how long before the insurer has to respond to our advocates to address that complaint. So it's a 60-day turnaround, but it's unclear in the question how long it has been, but if it's been more than a couple months, they absolutely should be calling their insurance commissioner and find out what that timeline is and file a complaint. It's a very common call that we get, is these kinds of delays. So they're not alone in this. And that's one of the reasons why advocates are there for them to help them with this.
Tracey.
Absolutely. So I think, we would expect, our law in Colorado is 60 days to either agree or deny the claim. And they have to send status letters every 30 days telling you why they're not paying the claim. So in this case, it would be, we're still negotiating with your contractor, or your contractor hasn't responded. So at the 30-day mark, you'll get that. To be honest, we get quite a bit of interest in Colorado paid to our Colorado consumers because of the delays. So I think we look at it, we want to see them actively working these claims. So if that means that a contractor is reaching out with a competing bid, we want to see action that they're trying to resolve that with the contractor directly, and they are under time limit.
Okay. Ben, is every delay actionable? Is every, when you hear this, and there's sort of this, I'm having this problem and this problem, does it all kind of add up to give somebody grounds to file a lawsuit?
Not necessarily. And I think people have to be very considerate of the fact that lawsuits are not easy. It's tough on people emotionally. It's tough on them time-wise. It reactivates negative experiences that they've gone through. And there are a lot of reasons for delays, some of which have nothing to do with somebody's decision to, act in bad faith or to just not honor their obligations. Mm-hmm. Sometimes the delays are because, there'll be a 250-page estimate that takes time to get through. Now, again, it depends the circumstances that you're in, but in a underinsurance context, which is again my focus, a lot of times the folks will say, we just disagree with this estimate. It's $1,500,000, and your policy limits with the extended coverage are $800,000. We've got our own estimate that says $800,000, so we really don't have an interest in delving into the details of yours. It's way too expensive, and it's way beyond the policy limits. I mean, that's mm-hmm. where, there's delays I've seen of months and months, I think 9 months in one case that I handled, where they couldn't get a straight answer on the insured's contractor's bid, other than, we've agreed to pay your policy limits. We sent you a check. We don't agree there's underinsurance involved, and we don't need to look at this in any more detail. So, mm-hmm.
So there's not a hard and fast rule about how many technical violations of the 10 days to reply add up to something that say a Department of Insurance would take action on, right? Okay, let's get to the next question.
So the next question is from JP in Colorado. Can you expand on how to dispute the depreciation lifespan, both structure and contents?
Okay, well, certainly, again, at our website, we have some pretty good resources on establishing a fair depreciation. But I want to throw this to, let's start with Tracey, since it's a Colorado question.
Yeah, so I think there's two separate questions, right? So you have the dwelling, and so that might be able to, it's even a little easier, right? The house was built in a certain year, right? And hopefully you have records of any improvements that you may have made. So those are going to be, those could be really good pieces of evidence that you supply to the company, right? They shouldn't depreciate a home, 20 years if it's only been built for 10. So there's that. For the contents, again, it's condition, and no one's going, if it's a total loss and then it's gone, it's hard to defend that, but you just make the case that, yeah, I have these 2 living rooms, but one was never used. So I guess to expand on it, how do you, negotiate that depreciation? You make your case. I think in other United Policyholder webinars, it was talked about, this is the time to reach out to friends and family for photographs. If you don't have invoices, perhaps they have photo in the background, you can see some of your personal property. And like many of the issues that we've discussed today, it's really negotiation. It's being consistent too, and being persistent, I should say, and make the case and put it in writing and get them to justify their responses. But it may be tedious, but it needs to be done so that you can get the full dollar amount. And the contractor hopefully is going to benefit you on the depreciation for the dwelling to some degree.
Thank you. Okay, next.
Okay, so there are a couple of other questions, we're going to go in a different direction for a little bit here. Our insurance company has cut off our ALE. This is SR because we won't just clean and go home. So apparently this is a partial loss situation. We have no limits to money on our housing for ALE, just time limits. We feel they're trying to get us to use all of our resources on Airbnb fees and continue to pay our mortgage. We have moved 14 times since September 2020 with 3 children. I think the bottom line with this one is, we may not have enough information to give her a clear answer, but it looks like the problem is cutting off ALE without full restoration of a partial loss.
Okay, so for any of you regulators, let's start. Does it say what state this person is from?
I believe it's Oregon.
Ah, okay, Nancy. Somebody's getting cut off or threatened to be cut off prematurely on their ALE. How do they establish that they still need, that they're still entitled? That we would say, as long as you've documented that you're being diligent in trying to find housing or being diligent in trying to replace your home, they certainly can't cut you off, but the limits are a little shorter in that state. So what would you counsel this person?
Right. I think, Amy, as you said, it's essential that they be documenting. It sounds like from what was described, it's not a full loss, but a partial loss. And it was perhaps their smoke damage. They said just clean and go back. So I'm not totally clear, obviously, of the details of the case, but they should be documenting why it is not yet livable to go back, have experts helping them with that documentation. And again, reach out to us. And the more information you have to give us, the more details, then we're going to be able to see how we can help you. Every contract is unique and every situation is unique. And so it's challenging to give you a satisfying answer in this situation right now without knowing the details. But this is a great example of why you'd want to call our advocates, explain the situation to them, run through what you've been through, and share with us all of your documentation. Throughout this whole evening, Amy's been emphasizing that importance of having all your records in shape. And my advocates tell me time and again, when a consumer comes to them with those records, it makes that complaint process work so much smoother and to success. So think about it that way too, as you're keeping that information. It's going to help you if you're going to work through our office also. All that documentation is going to help with your complaint also. I assume you're going back to.
I'm sorry, I'm making everybody
Contact
dizzy. I'm going to make everybody completely dizzy. Don't look. Don't, and I'm hollering, don't look. All right,
I
here we go.
appreciate it. I think I know
here's-
what you're trying to do.
There
and I
we go.
appreciate it, Amy, but
That was one of
it's a
them.
good time warp. But thank you for that.
Yeah, here we go. I'm trying to get us. I'm
Yeah,
trying to get us.
our website's right here.
There we go.
Yeah.
There we go.
Thank
There
you.
we
Yeah.
go.
Yeah, and our website's right there.
there
on
we
the
go.
screen. Please
All
reach
right.
out. This is a situation where, we definitely want to help
Yes.
you out.
And and partial losses can be harder than total losses because of the subjectivity of the situation and the challenge for the homeowner of establishing that it's not safe and healthy for them to be back in their house. So yes, by all means, do try to access help from Nancy's agency. Next question.
Okay, this is PR, and I believe this is in Colorado. I have been diagnosed with a mild cognitive disorder and have repeatedly asked State Farm to answer my questions in writing. They don't refuse to do it, they just don't do it. They pick up the phone and talk to me fast. I request that they send me an email synopsis and they just don't. I sent a letter requesting a settlement on my personal inventory, and they've been unrelenting that I must send them an itemized inventory if I want more than the initial 30% of my limit. Any suggestions? Colorado.
Okay, let's start with Tracey.
Yeah, it can
You need us
definitely.
to-
it
Do you
can
need us
be-
to?
Yeah, it can be difficult, that's for sure. So, you may need some help, but one of the things we would expect the company to communicate with you in the manner that you want to be communicated with. So if they're calling you and talking fast, you ask them to put it in writing. And if you give them questions, I say bullet points and numbers and specifics so that they can respond to you using numbers, the answer to your question one. And it can be hard to get them to give you an answer that you understand. You can always call us too. We're out there to help. But again, in writing, separate from different coverages, try not to bulk them up. But we would expect them to answer you in writing if that's what you prefer. So if they're giving you a hard time for that. And then we're back to the inventory question. Anything over the 30%, we're seeing variation between companies. If the company just determines that they want that inventory, there's not much we can do. And we can make the case for you. We can try to advocate for you. But we don't have a statute that we can use to compel them to make that payment. We'll try every other way we can, but ultimately it will be if they require the inventory, then that's what's going to be necessary.
Thank you. And I'm going to just interject here for a second because we got a number of questions around the same topic of what we talk about reformation, meaning retroactively reform the policy limits for the person who's underinsured. Ben can certainly speak to what the law is in California and the challenge. For any of the Oregon, Washington, or Colorado, does your agency get involved in helping people retroactively reform their policy limits if they're underinsured?
And this is Tracey in Colorado. So it has to be a really great argument, right? So we were able to help a consumer who had called their agent just days before the fire and talked about the replacement cost. And she had documentation from a builder or something to support the higher limit. And then the agent just failed to process that, right? So they failed to process it. Well, the agent's acting as the company. So because of the agent's error, we were able to get the company to reform the policy to the amount that she had requested just days before the fire. Very unique situation. I've seen emails back and forth between agents and consumers, and I would think that the case was made, but the company will say, no, that case wasn't made. The consumers, it's on the consumer. So we've had luck. It's not often though. It's a hard case to make. And often the claim will be settled and then they'll go see an attorney after that, so
Right.
sometimes
Yeah.
you have to set that aside and get through with what you have to get through with and then work on that part after. It's a very big lift.
Yeah. Nancy, anything to add?
No, at the same point as Tracy, which is it has to be a very clear-cut case where obviously the consumer said, I want my limits increased and the agent didn't do it.
Right. It
Really
can't
well
be
documented.
documented. That's the key. We always say, he said, she said, almost never wins the day. But the one he or she with the most notes wins. Anything to add on that, Josh? Anything from Washington State? It's tough.
Same things.
Yeah, it's tough. And Ben, anything to add beyond what we've already talked about with making the case that it wasn't the homeowner's fault?
Just as documentation after the fact is important, having recordings of the actual conversations can be very, very determinative. A lot of insurance companies are now taping their conversations. And in one case that we had, the agent said, "We'll get you enough coverage, quote, so that it all gets rebuilt." And that was the mantra in our lawsuit. The clients said that before they got the recording. They finally got the recording and it confirmed what they recalled. They gave it to me, and that was up front and center when we were required to sue the company. And ultimately, they got enough money so that it all got rebuilt. So don't forget to ask for recordings because they can cut both ways, right? If the client recalls one thing, but the agent didn't say what the consumer thought was said, it's better to know that early.
Absolutely.
Oh, okay, this next one's in Colorado also, and it's pretty interesting because I think this is happening in a number of areas. The market is very limited and it's moving fast for replacement homes. This is from CS. We are considering purchasing a replacement home instead of rebuilding. This is particularly happening a lot because people are underinsured. In our area of Colorado, the average time for listing to sale is 4 days. We're concerned that the insurance company will require time and red tape before releasing the extended replacement coverage, and thus will never be able to conclude a sale within the timeframes required by the market. Do you have a suggestion for using this situation to convince the insurance company to pay the extended replacement coverage now, or at least place it in an escrow account so that it's readily available when we find a home we'd like to purchase?
Tracy, you want to take a
Yeah,
crack at
I
that?
mean, our market, oh my gosh, I don't know what it's like in your state, but it is absolutely true. These houses are going crazy and they're being sold at, 10, 15, 20% over
Over
market.
asking.
And yeah, it's just incredible. I think in this case, you sometimes can't wait for the company, right? You have to make the decision. So hopefully you've paid off your mortgage, or you don't have a mortgage on the house that you've lost, and you have a little bit of money so you can continue to have these like two paths, right? You're working to get that closing, and you really do have to move fast and you have to move aggressively. And then knowing what your policy affords. What is the top dollar amount that you're going to get from the company? Knowing the companies move slowly, these sales move very fast. So there is that, you have to make that determination. Should I just move ahead, knowing that I have another $65,000 sitting on my policy for replacement cost coverage when I sign the contract? So hopefully there's a little bit of money to play with, and you have that, your paperwork all lined up for your new mortgage. But I wouldn't wait for them. If you don't have to, I wouldn't wait for them. I'd go. The claim still exists. You can still collect that money. If you're waiting for them to hand it to you before, without a contract, I think that would be challenging.
Okay, next question.
Okay. This is a pretty straightforward question. Does the insurance company have to respond with an affirmative or negative answer when you demand all of your policy limits in writing with a time demand? We were underinsured, had a total loss, and asked for limits right after the fire. On September 7th, they just responded a few weeks ago, ignoring the time demand with a summary of what they had paid thus far without answering the initial demand at all.
And that's a clear-cut violation. They have to tell you what your policy limits are, and they have to do it in a timely fashion. I don't know that any state gives a leeway on that issue. So that's one that I would take up with your commissioner's office.
Thank you. Okay, next question.
Okay, let's see here. This is a California question. We had a total loss in September of 2020. The California, excuse me, Fair Plan made a partial payment in December, but nothing since. They keep sending the claim back to the field adjuster to make changes, but they're minor issues. We were obviously underinsured, and it should be a full limit loss. Is the delay bad faith? By the way, they are over 2 months behind on the FRV. I'm assuming they mean replacement value
Right.
payments, and are indicating they will pay below the policy limit for the dwelling, which is still way below what the cost would be to replace.
All right, I'm going to throw this to Ben, but first throw out a caveat that, you know, a question like this, you know, is this bad faith or not? It often depends on who you ask, you know, and how good the lawyer is that you could get to represent you on a contingent fee. But that said, Ben?
I would need to know a lot more of the underlying facts. It seems that there are some bad issues that are going on here, some bad facts for the insurance company. Generally, delay in and of itself can be evidence of bad faith. If you have a dozen instances of things that haven't been done right, whether it's starting with failing to deliver a replacement cost estimate at the outset when the policy was first implemented, to various internal communications about, well, let's not do this, let's not do that. It can be bad faith, but again, I don't throw out the bad faith concept until other things are firmly established, such as, is there a basis for claiming that you were grossly underinsured? In this case, it sounds like the insurance company is saying, they don't even have to get to policy limits. So those fact-intense issues have to be addressed very, very early on and thoroughly. And I've been known to take months before accepting a case after looking it over, because I don't want to, expend my time or the client's emotions and have expectations that are, unrealistic if there's not a good factual basis for claiming underinsurance and or bad faith. Because once you make that bad faith allegation, it's basically a declaration of war here. And if you can resolve things without going down that path, it's often in everyone's best interest to do that.
100%. And when I was giving everybody whiplash going through the slide deck before, we do have a number of slides in the deck about options for resolving disputes over the valuation of a home without going to litigation. Some mediation, appraisal, and the bottom line is really, if you feel that your insurance company is acting really unreasonably and in bad faith, and not in a small way, not that they, but in a kind of a sustained and a pretty expensive way for you, consult with some lawyers. In this field, the attorneys that you find in our find out directory, or that you would hear speaking in our programs, almost all of them will only take a case on contingency, meaning you don't pay them by the hour, but their fee is a percentage of whatever they recover for you from the insurance company. And of course, that has the advantage for you of having, you don't have to pay them by the hour, which is not realistic for practically anybody. But it also kind of makes your interests aligned with your lawyer's interests. But, the quality of lawyers vary, and, some of the better ones are pretty picky about, there has to be a fairly large amount of money at stake and all that, because when a lawyer takes your case on contingency, they're betting on the come. So they're going to, and they want to know that you have a really strong case. So what Ben is saying is gold, and that and that's why we're here tonight, is to try to help you think through, is there something I could do without having to file a lawsuit, right? That's kind of a lot of what we're talking about here. But it is incredibly frustrating to be, a lone disaster survivor up against a big business that has all the resources in the world, it feels like. So what we're trying to do is try to help bolster resources for you, so that it's not like Ben said, it's not just saying I'm going to sue you for bad faith is not really going to get you anywhere. It's really depends on the facts in your situation and what do they look like? What's the history of back and forth?
May I say one thing? So I think that if I understood the question right, the policy limit is more than what they're now valuing the home at. So we had a consumer that did that, and I actually asked them for a refund of premium. We just talked about that early on. Who sets the replacement cost? It's usually the company. In this case, the estimate was coming in well below what the policy limit was. So we put it back on the company. You calculated it. Interestingly, it wasn't a premium refund. It was an estimate revision that went way over the policy limit. So, but that might be a tactic. If you have a $500,000 RCV, but your estimate's coming in at $250,000, where did they get that? Why are they charging you for so much more of value of your home?
That's a very interesting point. Very good point.
Quickie question here. My insurance company records all of our conversations, just like Ben was talking about. Is there a way to get access to those recordings, and how?
Well, certainly in California there is. We have a law in California that gives the insurance consumer the right to get copies of all documents in their claim file. So if those recordings are in the claim file, I would argue that you have a right to get them without having to hire a lawyer or do anything other than ask for them. But Ben, do you have something more to say about that?
As a practical matter, insurance companies say, well, those recordings regarding the underwriting of your policy are in a different department and they're not part of our claims related files. So you can't get those without a lawyer. And I've had clients come and say, they say I have to have a subpoena to get that. And I say, well, that's crazy, because the subpoena implies that a lawsuit's pending. And does the insurance company really want a lawsuit pending just to get some recordings? And invariably, after I write a letter, I'll get the recording within 15 days and we'll hear what it has to say. But they often push the individual consumers around and say, no, you're not entitled to that. That's our recording. You don't get to have it. Which is nonsense.
Yeah. Josh, anything to add there on?
In Washington State, I regularly request it, and there are times where the insurance company truly doesn't have it, and so they'll tell us, unfortunately, that was one that was not recorded, and I don't have a way of auditing that. I can't verify whether or not they're lying to me, but I take it in good faith that they're telling me the truth on that. But no, the requests for information, the insurance company should provide it to you. But, based on regulatory authority, they do have to listen to us on those kinds of things, at least again in Washington State. I don't know how it is in other states.
Yeah. Nancy, anything on this?
Same in Oregon.
Okay. All right, we're closing in here. Amazingly enough, we've had a phenomenal participation and a lot of questions, which is great. Our panel has been amazing. We've got one more question, and my staff has been amazing answering questions behind the scenes as well. If your insurance dwelling replacement cost reads, we will settle covered losses to the dwelling under coverage A up to 125% of the limit of liability shown. Is that in addition to the limit or a total of 125% of the total? So this is actually maybe something that's going to be hard for you guys to answer without seeing it. If you're like me in math, you have to see the numbers. But look, Josh, do you understand the question?
Yeah, so what's important to know is figure out what your coverage A amount is. So for easy math, if it's 100,000, and that's a very low number, but the math is easy. If it's 100,000 and your replacement cost or additional coverage is totaling 125%, then basically in the event of a total loss, your policy can pay up to $125,000. It's not 125% plus your coverage A. It's your coverage A plus that overage, which would be that 25%. What's nice about that question is it also touches on some of these material cost increases. And if you've got a $400,000 house and you've got a 25% or 125% extra replacement cost, that's an additional $100,000 available for your home. And so in the question about material costs, a little harder on houses that may have already burned, but I would recommend anyone with a current house to give your insurance company a call and say, hey, rerun my replacement cost estimator based on today's figures, and remind me of what my extra replacement cost coverage is so that I can have some confidence about that. I recently did that because my wife's in construction, and so she tells me all the time about the cost of OSB today versus a year ago. And so I called my insurance company right away and said, hey, let's look at these numbers. So that's something to take a closer look at as well.
Yeah, but the math of calculating how much your extended replacement cost gives you, whether it's 125% above or whether it's 125% of, does that mean, Tracey, Nancy, anything you want to add on this and helping consumers figure that piece out?
This is one where you really want to see the policy, right? You really want to dig into that policy to see what those, because is it an and, is it an or, is it above? So I don't have really enough information to answer. I think you really have to dig into that policy and understand the verbiage.
Absolutely. Nancy, anything?
Yeah, I mean, I would just add, this goes back to sort of a settlement strategy, which is you have to be the expert on your policy and your coverage, and use your agent as your tutor, right? They can't necessarily help you with your settlement, but they can help you understand your policy and your coverage. And so really go through that. If you don't understand something, say, explain that to me in simple math, like exactly like Josh just did. And take notes right on there. This is what he told me that means. Like really get it in common language so you understand, and keep asking questions until you really understand each of those sections. And your agent can be a resource to do that.
Yeah, and I think, there was a situation where there was a mobile home park and a lot of that had a horrible fire. A lot of homes were destroyed. And a lot of them were insured with the same company. And, we took a look at the policy, and it had this or and that Tracey was talking about with 100% extended replacement. And the company was saying, yeah, no, it's just that you get 100% of whatever it is. And we said, well, that can't be right? If it's an extension, it has to be doubling, right? But we had, there was sort of a war of words, but the policyholders ended up winning that war of words. But it took it took arguing on the basis of those words and digging into the policy, just as Tracey and Nancy and Josh were saying. Ben, anything to add on reading the policy in your favor?
Yes, one of the first things I do is do an Excel spreadsheet that takes every coverage and every extra 5% for plants and every 25% or 50% for extended dwelling coverage. And I put it into a chart, and I see what the insurance company has said in communications with the clients. And I use that to determine if there is, once again, under insurance, what the amount should be for these other coverages that they have said, we've already paid these all off. And we'll say, no, that's not so fast, because they're all dependent on coverage A. But the policies can be confusing. And if it's an and or, and they say, well, you only get 100%, what is the purpose of the language there? It's surplusage. And of course, contracts shouldn't be read to have surplus language that doesn't have any meaning. So I think the question's good, and the answers that were given before me were certainly good as well.
So we have gone a long way here. We've answered a lot of questions. We have one more that I cannot resist throwing out. Our panelists have been angels to be with us this long. And my team, I so appreciate it, but I really do think this is an interesting question. Is there a problem with us recording all calls with the insurance adjuster and restoration company? I'm going to start with the lawyer first. Ben, is there a problem with that?
Well, it depends what state you're in. In California, it's a two-party consent state, and that means that all parties have to consent to the conversation being recorded. It's actually a criminal offense to record somebody without their permission. Other states, New York, for example, it's a one-party consent state, which seems kind of crazy because I can consent to me recording you without your knowledge, and
I
that's
consent.
completely legal.
Right.
But just as insurance companies, give you that recording that says, we're, for quality control purposes or whatever comment at the beginning, we're going to record. I think it's perfectly fine that permission be asked to record conversations with insurance, claims people or agents. They may resist that because they only like to do that on the underwriting side as opposed to the claim side, but can't hurt to try.
Tracey, this came from Colorado, so do you happen to know what the law is in Colorado?
It's a one-party state, so you can record whoever you want to, whenever you want to, without their knowledge or consent. I wonder, then you'd have to get somebody to just transcribe those calls, but you could. I come from a state, though, Massachusetts, where it's actually a felony. You have to get their knowledge or consent. So notice the or there. So you either you can tell them I'm recording, and they say, well, I don't want you to, but now they know you are.
Right.
So you don't need both. So again, you really have to look at the state. I wouldn't want to ever tell someone to go ahead and do that and then face a felony over a claim.
Yeah.
There's
agreed.
There's one more, Amy, that Val has forwarded because there were several questions to this
Okay.
from different people. And so this one kind of sums it up. And this has to do about, there was a question about a new adjuster, but what about a situation where the adjusters keep getting changed with no notification of the change? This happens a lot in Colorado. And then the new adjuster says that the prior adjuster didn't complete any of the changes or the work that was requested. So now you have to start over, and it's a 3-week, another 3-week delay, and you have to communicate all of this again.
Okay.
This is in Colorado, but those questions came from the other states too.
So what is the question? Is the question, is it legal for the new adjuster to make you start from scratch?
What can they do about it? And,
okay. Okay. All right. So what can a person do if they're going through rotating adjusters and the new adjuster is kind of starting from scratch? In California, we have a law that requires that if you get more than 3 adjusters in a 6-month period, that the insurance company has to give you a status report in writing. I don't know that is the law in the other states. So just from a practical standpoint, Josh, is there any requirement of continuity between adjusters on a claim?
Communications requirements still have to go through, but I'm not aware of any specific laws regarding if there's a change of adjusters or a certain number of adjusters. It kind of goes along the lines of wishing you had a new adjuster sometimes, and where we don't have anything on the books that helps direct that, I don't believe.
Okay. Nancy, anything in Oregon?
No, and we're definitely seeing this. We're hearing this from our folks in Oregon. So I'm sorry they're going through this. This just, again, reemphasizes that getting everything in writing, taking good notes, keeping yourself really well organized, because you become the expert of the whole case.
Yep. Tracey, anything in Colorado?
There's no law, but we definitely don't take kindly to that. And I mean, we've had conversations with companies directly about that because the consumer is looking for a resolution. And every time you get a new adjuster, they're starting from scratch. And that means that they're looking at notes, and there's those files and that knowledge that new adjuster is going to gain is only as good as what's documented.
Yep.
So we've had consumers come to us with emails that show that the prior adjuster agreed to something and the new adjuster it's not in the file. So they say no. You know, if it wasn't in writing, the consumer most likely wouldn't get it. So that's why, again, you have to go back to keeping really good communication records. But we're not going to look the other way. If they're changing adjusters results in a delay, an undue delay, we're going to hold them accountable for that. So we don't start the clock on the 60 days to pay or deny a claim just because a new adjuster has stepped in.
Yep. Yeah, and I think, again, I'm sure, Ben, it's, we've talked about this. It's sort of a continuum of like, how many bad acts add up to bad faith, and it really is a very fact specific analysis, right? So
Absolutely.
yeah. So I wanted 2 reminders. Upcoming and recordings of previous of this type of workshop can be found on our website at uphelp.org and events. I'm going to advance the slide in a minute here, but also for those of you who are still with us, and I'm amazed at how many of you are still with us, and thank you. We know just as much as I want to thank our panelists, I want to thank all the attendees. We know what a challenging situation y'all are in, and it's a long day, and I hope that we've been giving you a lot of good fuel to keep going. So those of you who are in Colorado, we're about to close a survey that we have had open, recovery status survey. We really, if you haven't taken it, please take it. We only have like, I think about, 57 replies, and we know there's many more of you out there. Our survey results can actually help us help you get concessions out of your insurance company. So when we publish, as we're about to do our California survey results, and we show that some insurers are waiving the itemization requirement, that helps put the pressure on other insurers to do that. So taking the survey is not just some kind of empty thing. It's actually can really help you. So please do that if you haven't already. Here's our upcoming events. Next Tuesday, we have another one of our Survivor to Survivor forums. That's sort of a more informal kind of a hangout with, and we will have some of our really savvy, incredibly, one of them very funny people that went through similar what you're going through, obviously never identical, but similar. Some insights, comfort. Next Tuesday, you see the times there, free. Just register on our website. We'll be doing another Q&A for California folks, June 16th, and one for Colorado, June 23rd. The relationships that we are building with our friends in Oregon and Washington are incredibly valuable. We're so grateful. Nancy and Josh and Josh, so grateful. Tracey, you've been phenomenal. Ben, so generous with your expertise, all 4 of you, your time. Tonight was kind of a long one, although I have to say pre-COVID, when we would do these things live, we would always go this long. But it's, a lot to ask people to sit and look at a screen and listen. But we just seeing how many people stayed on all this time means that your expertise that y'all shared tonight was really well received and very valuable and very much appreciated. So thank you for sticking with us, answering all the questions. Thank you, Carrie and Elise and Val on my team. Y'all are stalwarts. Thank you to our funders in California, our funders for Colorado, our funders for Oregon and Washington. The Center for Disaster Philanthropy is an amazing organization that is making it possible for us to be helping out in all 4 states. those of you who are still on, and there are actually still quite a few of you, if you have friends and neighbors that don't know about this, let them know about it. It's free. And this is how you can encourage people to sign up. If you want to get a copy of tonight's slides or video, info@uphelp.org, we will be very pleased to share it with you. We have plowed through an amazing number of questions, and I want to wish all of you a safe and restful evening, a good night's sleep. And again, thank you all for your time, your attention, and your energy. Keep it positive as you can. We're rooting for you at United Policyholders. So hang in there and take advantage of all the free help we offer through our friends, Ben and Josh, sorry about that, Tracey, Nancy, and all the people that you will be able to listen to if you go to previous recordings. We offer a great spreadsheet. Val wanted me to remember to remind all of you, we have a terrific spreadsheet. I don't know if this share is going to work here, an insurance accounting spreadsheet where you can, it's not going to work, but I'm going to show it to you right now. An insurance accounting spreadsheet that we offer on our website to help you keep track of all of your claim expenditures, or I'm sorry, the monies that your insurer has paid you so far. So staying organized is always, it's hard when you're walking this challenging path, but it is definitely should be an ongoing goal. Journaling and trying to keep your paperwork organized. So again, good health and good night. Thank you all.
Thank you, Amy.